Lately, we've seen extremism in politics and notably in religion, much of it in response to fear and anxiety about a world that's changing almost faster than we can stand. Is there anything we can do, each of us, to face the future without fear and anxiety? Well, the way to strengthen the future you is to strengthen the future us, in particular in these three areas: relationship, identity, and responsibility. Let's talk first about the us in relationships. While teaching in Canada, I met a girl who was my opposite. She was practical, financially responsible, and didn't like to be mentioned. In fact, she would very much prefer not to be a part of this talk. But I struck up a conversation about furniture with her anyway, and yada yada, we're married 13 years and have a beautiful daughter. It's the people unlike us who let us grow. Social science has shown that if we spend time with people who agree with us, we tend to become more extreme in our views. We need to get back to spending time, real time, face time, with people not like us, who it turns out are people just like us. Next, let's look at the us in our identity. Memorials like the Statue of Liberty and the Washington Monument have lots and lots of words to explain our story, as do our myths about heroes like Lincoln and Martin Luther King. We need to keep telling these stories over and over to maintain our identity. When we stop telling the stories, we begin to feel weak and vulnerable and alone. No wonder we feel inhospitable to strangers. We've got to get back to telling our stories so that once again we can begin to feel strong and no longer alone. Have you noticed that magical thinking has taken over our public consciousness? The far right is pining for a greatness that never was. The far left is dreaming of a utopia that never can be. The religious and anti-religious both agreeing that God, or his absence, is all that's needed to redeem mankind. But the only cure for mankind is not through self, but through we the people. We need to rediscover these counterintuitive truths: that a nation is strong when it cares for the weak, that a nation is rich when it cares for the poor, and that a nation becomes invulnerable when it cares for the vulnerable. Once we've diversified our relationships, focused on our identity, and taken responsibility for others, we'll be able to see ourselves in this famous quotation you'll recognize: "Yea, though I walk through the valley of death, I fear no evil, because thou art with me." Humanists believe that thou needn't be God. It can just be our fellow human beings, other earthlings, with whom we share the same problems. And we can surely face an uncertain future without fear and anxiety, and maybe without xenophobia, as long as we know that we will not face it alone. Now, this entire reflection has been plagiarized from the closest thing Jews have to a pope, Rabbi Lord Jonathan Sacks. I highly commend to you his sermons on YouTube. They're easy to find, they're less than 15 minutes long, and they're more or less secular. And they're spectacular. That's Jonathan, Jonathan, Sacks, just like Oliver Sacks, Sacks. And that's it from me.
From FFRF, we're pleased to have Ryan Jayne. He's going to look at some of the legal issues and church and state issues, I think some in our own state, our own great state, I should say, and also nationally.
Yeah, and thank you, Jim, for the that reflection. That was excellent and uplifting. I at least really needed that. With if anyone else is half as concerned about the state of this upcoming Tuesday, they definitely need to hear more things like that. And as luck would have it, in a otherwise stressed environment for myself and in my brain, I am right on Lake Michigan, which is very idyllic, but we're in a windstorm and our power went out about 5 minutes ago. So I'm currently hotspotting through my phone and going off of battery power. So on the off chance that I drop off, I really apologize. It's just that I'm going on what I have, but it should be okay, I think. So with that, I am going to share my screen and jump right in and talk about, as was mentioned, both some things that are going on state church-wise in Minnesota, and also more nationally.
Ryan, the power loss sounds suspiciously like an act of God.
Right? I know, it's just at the moment, there's like, no, this is not to go on. Okay. So yeah, as mentioned, my name's Ryan Jayne. I'm a staff attorney at the Freedom from Religion Foundation. I work on the strategic response team with Andrew Seidel. I'll talk a little bit more about that a little bit later, but in the past, I used to write letters. So I was one of the attorneys that FFRF was and is quite well known for writing these sort of nasty grams to public schools and government entities that have crossed the line of state-church separation, and asking them to take corrective action. So I can talk a little bit about that. But before I jump into it, I just want to remind people of where Minnesota stands on the picture of federal courts, because the federal courts are on a lot of people's minds, and it's something I'm going to be spending a bit of time on with the recent confirmation of Amy Coney Barrett. We're very, very concerned about the state and the future of federal courts, and Minnesota is in the 8th Circuit Court of Appeals. So if you look at this map, this shows where the appellate courts are in the federal court world. So one level below the Supreme Court, you have federal courts of appeals. And because you're in Minnesota, you go to the same court of appeals that people in Little Rock, Arkansas go to, for instance. So that's the way that our federal system is set up. And by the way, I should mention before I jump into the specifics, just because I can't see the chat right now, and for the sake of streamlined audio, if you have questions, please put them in the chat, and I'll do my best to address all of them later. I'm happy to stick around as long as I can anyway. Hopefully my power comes back, but happy to stick around as long as you guys have questions. I'm happy to chat afterwards. So a couple of things that we handled kind of closer to home for all of you. So Fergus Falls is has a public school system that we got a complainant about. There was a middle school class that, despite the pandemic, they were full online. And there was a student who posted a video of their teacher speaking at their church. And so this was in an online forum for the classroom. And what the teacher should have done, because he's, obviously talking about religious things at the church, which he's of course able to do, but it's not correct for that to be on the public school forum for the online class. So the teacher should have deleted this video right away when he saw it. At bare minimum, you'd expect him to ignore it and pretend he didn't see it, something like that. But instead, what he actually did is he commented on it. He encouraged students to share it with others who weren't in the class. And then briefly in class, he discussed the video as well and asked if kids had seen it. So at that point, he's full on endorsing the content of the video as his role as a public teacher. And to make matters worse, this is not the first time we've complained about this particular teacher. He in the past had been promoting some religious summer camps and whatnot that we had gotten resolved. So we wrote a letter to the school that had this paragraph just explaining what was happening and asking the school to look into this and to take corrective action. And again, this is something that probably everyone on this meeting is quite familiar with. FFRF is well known for intervening in this sort of way. And in this case, we got a really solid win very quickly. So the superintendent wrote back, said that the teacher agreed, should have deleted the video immediately, and short and to the point said, let us know if you have any other questions. Now, of course, because this is the second strike, so to speak, for this teacher, we're going to be keeping our eye on this school district, but the superintendent seems to be on the right page, and our complainant is in the school. So if more things go on, of course, we'll hear about it. And I have one more for you. So take a look at this advertisement for a baccalaureate. So this is ISD 728 in Elk River. And if anyone doesn't know, a baccalaureate is a religious ceremony that's tied to graduation, and it's typically held at churches. And there's nothing wrong with a church holding a baccalaureate to kind of honor the members of that church who are graduating high school. The problem is that public schools are not allowed to be involved. So see if you have anything jumping out at you at this page of the advertisement. And what it is this first column says RHS, so that's the high school facility, and it lists 4 members of the faculty, who are going to be involved. So that's kind of an issue. If they were parents, they could be involved, but they would have to be there as parents, right? Not as teachers or administrators. So this is already raising eyebrows for us. And here is a similar thing. You might ask, well, what are they talking about? Are they there just to say, I'm a teacher, I'm going to talk about academics? And when you look at the program here, the last item is a high school teacher giving the final blessing, presumably religious. So it's public school officials giving religious content at a religious event. That's a problem because it amounts to an endorsement of the church and its religious message. So once again, we wrote a letter to the school asking them to look into this. And we got this response, which was actually quite fantastic. And it's always good when you see this. And in Minnesota is one of these states where this tends to be the answer, where once the superintendent finds out about it, they take a look at the law that we cite in the letter, and they know that they are on the wrong side of the law. So they're not going to try to fight us on that. And I think often, very sincerely, the superintendents say, I did not know this was going on. And so they really don't want this to be a problem anymore. So here they said they're going to speak to the people who did it, look into it as an HR issue. And then next fall, this fall now, they promised that they would have it as part of the district's orientation and back to school meetings. So they're really trying to take steps to correct it. So I love this kind of thing because it's relatively minimal effort. It's just, one letter for us. It doesn't take a huge amount of time to get one of these letters ready. And even less time for the complainant to reach out to us. We wrote to the school, and it makes tangible, just solid change for future classes that you don't have to worry about, hopefully, this particular issue cropping up where you're in a classroom and your teacher is maybe talking with other students about how great the baccalaureate is going to be, and you feel outed because you're not a member of that church, not a member of that religion. That shouldn't be a stressor in public schools. And so I love these kind of quick victories. So that's a couple things we had in Minnesota recently. And Minnesota is really, like I said, not one of the worst states that we have, as you might imagine. We get a lot more complaints about violations and worse violations in kind of the Bible Belt. But there are issues going on everywhere, of course. So now I'm going to take a step back a little bit and talk about what FFRF has been up to nationally. So first, our legal department has been really expanding. So looking last year at 2019 and then into this year, we have really expanded tremendously. I've been at FFRF now for 6 years, and when I came on, we had 5 staff attorneys, and we have more, which I'll mention in a moment. But I'll just say last year we had 3,000 state church complaints, 1,000 letters that we sent to government officials, and then 200 of these out-of-court victories, like the ones that I just described. And this is a big bulk of the work that we are well known for and the work that we do. But more recently, because we've expanded, what we've decided to do is to, instead of just being a team of attorneys who are all writing these letters, putting out these small fires, and then working together on litigation, instead, we've decided to segment the team into smaller specialized groups. So we now have a litigation team, a legislation team, a letter writing team that are all working together to achieve all the things that we try to do. So a couple people, when you think about lawyers, you always think about litigation, you think about lawsuits. So I want to talk just about a few highlights and lowlights that we've accomplished or dealt with recently. The first, so this is hopefully a picture many of you have seen if you follow FFRF on social media. This is Ben Hart, who is an FFRF member, longtime proud atheist, and he had a license plate that said "I'm God," ironically, obviously, in one state, and then he moved to another state, Kentucky, and they said, "We can't have this because it's offensive," basically. And we were happy to challenge that in court because it is quite an obvious issue of censorship, even though it turns out license plates are a really fascinating, unique area of law. So we had to kind of delve into that. But in the long run, Ben got his license plate. It turns out that Kentucky state had been very inconsistent with which messages they had allowed, which they hadn't. And long and short of it is they allowed most religious messages, but they didn't allow this one because they thought it was blasphemous, in short. So they pretty quickly, the court pretty quickly saw that there's no way for the state to win this. So they finally just surrendered and gave him his license plate. So that's a nice victory, although it took a great deal more effort than writing a letter. We had to, deal with the whole lawsuit for it, but we got it and he got his license plate. And then on the flip side of things, this is the cross in Bladensburg that the Supreme Court dealt with recently. And if you can believe it, this gigantic monument in the middle of government property, they said did not amount to an endorsement of Christianity by the state, which is this has just kind of made all of our heads spin. We saw it coming in a way when they took the case and everything. We thought, oh, geez, this is what they're going to do. But I'll mention more about the state of the federal courts later. I'm sure people have questions about it. But this is a very rough decision that the Supreme Court recently came out with that is really threatening the jurisprudence of state church law in the past 70 years. And as a result of that, there were immediate ripples and ramifications, including this cross, which is in Pensacola, Florida, where we were challenging a very similar set of facts. This is a giant cross that had a religious background on public property. The government had been maintaining it. And at the lower levels, we won. And then they appealed and we won again. But the judges there clearly didn't want to rule in our favor. They said, well, it's so sad that we have to tell them to take this cross down, but the precedent is so clear, we have no choice but to rule in FFRF's favor. So the moment the Bladensburg cross decision came out, immediately they came back and said, thank goodness we can keep this cross. So those crosses still remain and they are on government property and ostensibly don't violate the Establishment Clause. So that is, to say the least, very concerning about the state of the federal courts. Lower courts are bound to apply those decisions. So those are some things that our litigation team has been working with. And again, I'll talk about that a little bit more later. But I do want to touch on the very rapid growth of our legal department. In 2007, we didn't have a legal department. And then since then, we've been adding about one permanent attorney per year, which is really awesome. And it's been neat for me coming in about halfway through that process to see when I came in, it was a small team, and now we're expanding. I'm one of the more senior attorneys. And as I said, we're able to specialize more, and we're very quickly branching out and able to achieve state church goals in a variety of ways. So it's really exciting compared to just what we were doing when I got there. So in addition to these staff attorneys, we also have 2 legal fellows. These are rotating full-time attorneys, fully licensed attorneys, who the idea is we work with them for 1 to 2 years, and then we kind of send them off into the legal world, having studied and worked with us. And then we have a DC lobbyist, Mark Dan. This is a new thing for FFRF, and I'm going to talk about legislation in a minute, but it's a really important thing. With the courts being so uncertain, we can't really rely on the federal courts the way they are right now. It's more important than ever that we are focusing on getting good laws passed and clear laws that even kind of hostile judges can't get around. So having a voice for FFRF full-time in DC has been really tremendous. Mark sits with congressional offices every day and talks to them about what our members care about, what bills we think are good or bad, and develops those relationships for us. So that's been a really big change for FFRF, and definitely for the better. And then we have 2 legal assistants, and actually one of them, we only have one right now, Greta, who unfortunately, Greta Martins has had to be the only legal assistant through this pandemic. We were going to be giving her a partner, and then the pandemic hit and we haven't been able to do it. So that other slot is still vacant. If you happen to know anyone who wants to work with FFRF as a legal assistant, let me know. Okay, so to shift gears a little bit now, I mentioned the federal courts and how we can't really trust in the federal courts so much, so we have to focus on things like legislation more. But even more fundamentally than that, it's really important that we win the state church battle in the court of public opinion before we try to win it in the court of law. Because if you don't have the public on your side on this issue, in the long run, judges are not going to want to rule in your favor. Legislators are not going to want to pass laws that you like, and things will go in the wrong direction. So the FFRF is at its core an educational nonprofit. Even though we're well known for our legal work, we are an educational 501c3. And it's really important, more now than ever, that we remind people why state church separation is so important. So very happy to dive into any of these specifics later on if people want to spend some time on it. But some of the things that we have been doing that focus more on the educational side of things is filing amicus briefs, which are friend of the court briefs. In addition to actually trying to bring lawsuits, we weigh in to educate judges about what's going on and the public. We try to write books, we write op-eds, just getting into getting the public ear. We've written law review articles, doing other media. If you're familiar with FFRF and you follow us on social media, I'm sure you see, Free Thought Today and Free Thought Matters. We do Facebook Live events, many more, trying to again, just get out into everyday people and let them know why this is so important. And then we had a brand new thing just a couple of months ago, a law symposium that FFRF sponsored. This was in Rhode Island, where we had a whole team of law professors write papers about historical state church issues. We could basically give them a broad topic, and then they ran with it in their different directions. And then the idea was they were all going to get together in person and present their papers and give a talk. We had to do that online, obviously, but it's a really neat thing because these are people who are not tied to FFRF. These are well-respected academics who are now on the record with this academic historical work, showing things that we hope, and it definitely turned out this way, support the things that we are that we are trying to support. So things like in this case, is the United States a Christian nation? That was kind of the basic question that we asked them to be touching on. And so we know what the answer is. It would have been just shocking if an honest academic had come back and said, oh yes, absolutely, the United States is a Christian nation, because it's so obviously not. But so what this did is this created a greater and more recent body of academic work touching on this point. So when this comes up in the next lawsuit, where there is, the other side, one of the anti-FFRF groups is saying, well, Christianity gets special status in the United States because all the founders were Christian, something like that. We don't have to just go back to basic sources to refute that. We can point to this thing that academics wrote very recently. So it's a really neat development, and we have another one of those in a couple of years that we are just starting to put together. Okay, now I've alluded to this a little bit recently, but let's talk about the federal courts a little bit. Everyone thinks about kind of the state church world and attorneys like myself who work in it as mostly as people who work in court, and you get an issue, your rights are being violated, you go to the court, you say, First Amendment Establishment Clause, please fix this, and the federal judge fixes it for you. That worked, that started to work 70 years ago, and it worked quite well after that for a while, but the reality is things are quite rough now. If you look at just the Supreme Court, we haven't had a good state church victory since 2005. And even that one, which is McCreary, Ten Commandments case, was a Pyrrhic victory because it came out the same day as a bad result, which was Van Orden. And so looking back from there, it was 5 more years. It was in 2000 that there was a good case called Santa Fe. Since then, every state church case that the Supreme Court has taken has gone the wrong way. They are eroding the wall between church and state, which is very concerning. And then obviously with the confirmation of the most recent 3 justices, all of whom are hostile to state church separation and openly hostile to it, we expect that if things kind of continue the way that they look right now, they will get worse before they get better. So right now with Amy Coney Barrett being on the Supreme Court, to give some idea, we used to talk about Kennedy being the swing justice, so to speak. He had the swing vote. He wrote that Santa Fe decision in 2000. Justice Brett Kavanaugh is now considered the median justice in terms of the court's center of mass on ideological issues. I apologize for my clock going on, but hey, lets me know how I'm doing on time. So that's very concerning. If you remember his confirmation hearings, and he actually, so in that same case, that Santa Fe case, Kavanaugh, by the way, was on the team arguing in favor of the school. I won't get into the facts of it, but it was a prayer case at a public high school, and Kavanaugh was on the team arguing in favor of allowing the prayer. So we can't exactly count on him to uphold that decision. And he is now the center of the court. Very, very concerning. And then President Trump, I can't, because we're a 501c3, I can't weigh in on who I think anyone should vote for in this upcoming election, but I will just comment that a quarter of all federal appellate judges are now Trump appointees. And the reason for that is that when Obama was in office, he tried to fill all these vacancies that we had, and McConnell just refused to allow it once he got control of the Senate. They confirmed almost none of the judges, but then once Trump got in there, they started just cramming them through at an astounding rate. And it's not just the rate, it's also that these are young ideologues with lifetime appointments. So these judges are going to be there for the rest of their lives until they decide to retire, and they are hand selected by the Federalist Society to be far-right judges. So very scary stuff. Now here's something you might not know as much about, because a lot of that is probably stuff that is, horribly as it is, very well familiar to a lot of you. So in Minnesota, there are 277 state trial level judges. So if you have some sort of issue, civil or criminal, you go to court. The first level of judges that you go to, there's a pool, it's divided geographically, of course, but a pool overall of 277 state trial judges. And so here's a question for you. How many federal judges do you think there are in Minnesota if you bring a federal civil lawsuit, or if you were charged with a federal crime? So you go to a federal court and you talk to what we call the district court in the District of Minnesota. How many judges are there to deal with the caseload of the entire state of Minnesota? And the answer is there are 7. And that is a real problem if you think about that. Now, there's more state law cases than there are federal cases, but not to this degree. This disparity, 277 to 7, and this is not unique to Minnesota, this is everywhere in the country. These 7 federal judges, you might imagine, have an immense workload, criminal and civil, and they are massively backlogged. In fact, Minnesota is better off than many other states. Some places like California are so short-staffed. There are just so many people there and so few relative number of judges that when you bring a federal lawsuit, even if you get good judges who do the right thing, it can take years to get things resolved. And that is a real problem, especially if you're dealing with things like civil rights issues that are immediate and that have to do with things like public schools. If you're a senior and you are complaining about a baccalaureate that's happening in 6 months, yeah, you can sue over it, but it's going to be 3 years before the case gets resolved on average, probably, and you're long graduated by the time that happens. So this is a real problem, regardless of your opinion on the ideological side of the judiciary. This should be of great concern to American people, to anyone who cares about our justice system. In fact, it used to be a regular occurrence that Congress would look at what is the federal caseload and how many judges do we have? How backlogged are they? And then they would regularly revisit it and expand the judiciary and say, we need more judges to handle these. So we're going to add so many judges to each of the different circuit courts. And they haven't done that. I forget the exact year that they last expanded it, but I believe it was in the 70s. So it's been quite a long time. And this used to be, like I said, a regular occurrence. So when, there's a lot of talk about court packing and other issues of court reform. And I hate that term court packing, but I think that there's a lot of very good reason that everybody, there ought to be bipartisan support that we need some kind of federal court reform. The only question is what it ought to be. And this last point is one that I think everybody should be on board, that we need more judges flat out at the lower levels of federal courts. We can talk about the Supreme Court, that's a separate question. And then also, I think that the overrepresentation of right-wing ideologues is something that also ought to be addressed. So that's just some thoughts on that. And if that doesn't happen, we got real trouble ahead of us. So instead we come to legislation. Again, if we don't solve that court problem, this is the next line of attack, which is to focus on passing good laws and to fighting bad laws. And this is what I do on a daily basis. This is why I have this this title to this slide, because this is what I do every day. I track state legislation in all 50 states and federally, and every state does things a little bit differently. So when I was first getting into this, it was really overwhelming trying to figure out how each state, what is their process, their calendar, everything's just different. So in 2020, FFRF tracked 432 bills across 40 different states. And most of these states, just to give you an idea of the calendars, most of them meet in January and then they adjourn between March, April, May, somewhere in there. So this is really a first quarter focused issue. So if you're going to be an activist and you care about these things, get ready to be focused on this in January. And know that you don't have to focus on this year round. This tapers off once you get to the summer. You don't have to worry about it too much until the next year. Minnesota specifically, the way that it works, it's a 2-year process. And so they meet the first half of the year, but the way that it works is on odd number years, like next year, 2021, it's a longer session because it's the first year of the legislative session. So it'll be January through May. And then the even year, it's still a continuation of that session. So it's shorter. It just goes from February until April. This next year is the one where we'll be able to introduce new bills, and there will be a huge flurry of activity. Also, just want to make a quick note. I learned this as I was preparing for this presentation, thought it was really quite fascinating. If you didn't know that, as of right now, Minnesota is the only state in the union with a split control legislature where you have one party controlling one house and the other party controlling the other. This is something we see all the time federally, of course, with the Democrats controlling the House, Republicans controlling the Senate. A little bit less so at the state level, but there's 50 states. So you'd think that there would be more. And this is the first time since 1914 that there's only been one state with this mixed control. So really interesting. And I just wanted to say that's unique. And we could talk about why that is, but just a neat thing to note. Now, some of the things that we tracked in Minnesota legislatively this year. There were 19 bills that I was tracking, but most of these are either duplicates or companions, which are other copies of the same bill. I want to note, if anyone's not familiar with Project Blitz, it's something to kind of be aware of and arm your brain with for next year, because you're going to see these. This is Project Blitz is a name that they gave themselves, and now they're trying to rebrand themselves. But it's a group of Christian nationalist lawmakers who decided that what they're going to try to do is to, blitz, like blitzkrieg, all the state legislatures with all these bills that just kind of seep Christianity into the law in a whole bunch of different ways. So they had a handbook that we have copies of that say, here's this model legislation, and we want you to pass all these bills as much as you can in every single state. Just see what, throw everything against the wall, see what sticks. And these are things like putting up "In God We Trust" in every public school classroom, for instance. So we've seen mixed success with this, but it's something that we will absolutely be out in force next year. And we're going to be ready for it. And there are some of these in Minnesota. So you have legislators who in your state are advancing these bills. They have not been successful this year, but they will definitely be trying again next year. So keep an eye out for that. And as I mentioned, Minnesota is one of these rare good states that's actually passing good bills right now. I feel like we're mostly playing defense across the country right now, but Minnesota is really on the right track for things. So, for example, there were bills in Minnesota to eliminate child marriage. You may not have known that the law is that if you have parental consent, you can get married at 16 instead of 18 in Minnesota. With some other states, it's even younger. So that's something we're working to end, because as you might imagine, that's almost invariably a religious sect that has imposed that structure. Banning conversion therapy, obviously a good thing to work towards. So there was a bill for that. And then the Equal Rights Amendment is something we've, of course, has been working on for a very long time, but there was a bill in Minnesota this session to try to finally ratify the ERA, and you'd think that Minnesota is one place you could get that done. So this year, we got child marriage eliminated in Minnesota. So fantastic job there. Next year, hopefully we can check off those other two as well and see what else there is to do. So in terms of activism, keep passing good bills, show the rest of the country how it's done. Just keep up the good work there. As I said, pass conversion therapy, ratify the ERA. Another issue that Minnesota could catch up with on some more progressive states on this issue is death with dignity. That's formerly called assisted suicide, but obviously that has a pretty negative connotation. That's an issue that we think is a state church issue that has primarily religious opposition to it, and has been shown to be, I think, an undeniably good thing in the states that have allowed it. So that's something to consider supporting next year. And then, as I mentioned, as things like Project Blitz come up, just resoundingly defeat them. Let them know that they are not going to be, they're not going to become law in Minnesota. Now, other stuff that you can do. Minnesota is this kind of interesting spot where neighboring states really have trouble. So if you have connections in neighboring states, urge them to get active as well, because they cannot say the great things about their state that you can about Minnesota. All four of Minnesota's adjacent states have loads of bad bills. And right here in Wisconsin, we are certainly included there. So if you have any influence in those states, we need your help. And then use the tools you have. As a lay person connected to the internet, you have social media, you can write letters to the editor, op-eds. I think this is something that doesn't get done nearly often enough. We do this a lot as attorneys, but a lot of times, places that are, newspapers and other media outlets, they're looking for things to print. And if you're a local person with a story to tell, it doesn't take long. Most op-eds, I think, are supposed to be 650 words, something like that. So you can just sit down for half an hour, write that up, send it in, and a lot of times you'll get published. And so the squeaky wheel kind of gets the grease, and you can do that. And then and applying to legislators too. So for instance, ask yourself, do you know who your state representatives are? Do you know who your state senator is? And if you don't, but prior to coming to FFRF, I didn't know who mine was. So I'm guilty of being ignorant on this point too. But legislative offices get a lot of input from a very small percentage of people. So you should be among those small percentage of people. If you have the bandwidth to do it, you have the time, just reach out to them, tell them what you care about. They work for you. It's their job to listen to you and to try to make you happy, basically. So you shouldn't waste that opportunity if you have the ability. And of course, vote, vote, vote. Encourage others to vote. And my advice and this kind of goes back especially to the social media kind of things. You see so many people fighting on social media all the time, and I'm guilty of that myself too, but remind yourself that the goal is to educate people, right? We need to win this battle in the court of public opinion, and we need to get people off of their cynical ledge. So try to dispel cynicism, try to educate people, keep people positive, remind people why the things you care about are important. And if someone is just going to pull you down in the mud, then obviously you need to try to just move on. That's what I try to do anyway. So my final thoughts before we go to hopefully you have some questions for me is this is a big fight that we have. There's going to be a lot of challenges moving forward on both all the things I've talked about, basically the federal courts, legislation, public opinion. We need to just keep focused on what we want to do. This is like a big mountain that we have to climb, which is why I chose this picture. This is going to stay difficult before it gets easier, regardless of what happens in this upcoming election. So we have been so appreciative of all the support that we've had over the years, and I can say especially over the last few years, it's really been fantastic. And if you're tired, if you're fatigued, feel free to take some time off, and just kind of check out. I don't blame you whatsoever. We're going to keep plugging away. that's what we do, and we're all passionate about it. We want to fight for you. And if you're able, in January, when the new legislative sessions come up, that'll be the time to get back into it and stay focused and make some positive change. So with that, I will end my presentation, stop sharing my screen, and hopefully answer some questions. And we'll see what battery life I have left.
Wow, thanks, Ryan.
Oh, I'm good. I'm at 82, by the way, so don't even worry about it. We're just fine.
I had a question about, so I know more about FFRF than almost any organization in this general area. If you could say just a little bit about other organizations that overlap in mission. I would think the American Civil Liberties Union might be one of them with a broader mission, but it might include some church-state stuff. And also, what are the main nemesis organizations? Who do you see with the amicus briefs on the other side that we should be throwing stones at?
Sure. Yeah, that's a wonderful question. And we work collaboratively with a lot of different groups, including the ACLU. So for instance, I had a lawsuit in Indiana that I worked on with Sam Grover, and we partnered with the ACLU of Indiana to litigate this case in Concord, Indiana. It's a case you could look up, but the ACLU is fantastic. I mean, that just goes without saying. They have tremendous institutional experience and great lawyers, but they have a hugely wide net of the issues that they try to address. So I think they appreciate our more focused expertise and specialty in the area. So we kind of did a lot, the way that we divided the labor, was that we did a lot of the background work because we have the Establishment Clause expertise. They have more litigation expertise. So when it came to the nuts and bolts and procedural issues, they were just absolutely top notch. So yeah, the ACLU is wonderful. Our other kind of sister organizations are the American Humanist Association, Americans United for Separation of Church and State, American Atheists, and the Center for Inquiry. I'm sure there's some others that I'm kind of leaving out. So those are all ones that have legal arms that we potentially collaborate with, write amicus briefs for, and just all of those are excellent organizations. I endorse every single one of them. And then there's other groups too, like the Secular Student Alliance that we work with, that they don't do legal work, but they help us so much in the public opinion area, and especially with younger people in the case of SSA. So if you're not familiar with Secular Student Alliance, I also very highly recommend it. I know a lot of people who support this kind of work are on the older end of the age spectrum and kind of recognize that we need younger people to take up this banner. You know, we can't keep trying to fight this when we're, there's only so much that a group of retirees can do. You need young people entering the workforce who care about these things. So SSA is fantastic. In terms of the opposition, the biggest villain I would say that we face is, and there are quite a number of them. The biggest one is probably called ADF, the Alliance Defending Freedom. This kind of Orwellian name should always give you pause when it's a name like Alliance Defending Freedom. ADF is a terrifying organization. They have something like 70 staff attorneys. You know, I was just talking about how proud I am that we have 8, and that's a rapid expansion. They have dozens of full-time salaried staff attorneys, and they have a network of just hundreds of attorneys across the country who they've worked with and who are ready to take up cases with them. Just astounding, seemingly bottomless funding that they have, and tremendous political connections as well. So a lot, for instance, Amy Coney Barrett is connected to ADF. So despite our best efforts so far, we don't have any FFRF connected attorneys who've been appointed to the Supreme Court. So there's some real concern with groups like that just are so big, so influential, and they are representing a really tiny fringe of American belief that we should privilege religious belief above all else. So their view is basically that the free exercise clause should swallow the Establishment Clause. And if you can say that you have a sincere religious belief in something, that ought to presumptively give you an exemption to any laws that conflict with that religious belief. And the idea that the government can't endorse religion is ridiculous. That's their line of reasoning. So very scary stuff. So ADF, hands down, the number one. The other big organizations to watch out for are First Liberty Institute, or there's First Liberty and then Liberty Institute are two different ones. One of them, Liberty Institute, is the one that defended Kim Davis. First Liberty is in Plano, Texas. And there's other groups of that. They usually have liberty in their name or freedom, something like that. So you kind of know them when you see them. And when you look at their website, you'll always see that they're, standing up for Joe Schmo Christian who's being so terribly persecuted. So yeah, there's plenty of those groups to go around.
Okay, I think if anybody can unmute yourself by hitting your space bar, if you have a question to ask. I've got some more, but I'll hold my peace.
I wrote Ryan Jayne a chat message with a question.
Yeah, I see it. I'll read it out for everybody, and happy to address it. So it says the separation of state and church originates with the First Amendment, but obviously has been insufficient for a couple of decades. Agree. What would a new amendment be that would guarantee the separation? Maybe it should be drafted now, so the long-term ultimate goal of separationist organizations as the long-term ultimate goal. Yeah, that's a wonderful point. So yeah, point A is that state-church separation, legally speaking, stems from the First Amendment. I would say, historically speaking, it predates that, right? You can look at what did the founders mean with the Establishment Clause, the Free Exercise Clause, and especially people like Jefferson and Madison. They wrote prolifically about why they think it's so important that we keep state and church separate. And they wrote treatises and laws on this topic that shows that this is exactly what they meant in the First Amendment. So that's the refutation to when people sometimes say, they would look at your first sentence and say, oh, well, I don't see the word separation of church and state there. Anyway, this just says that the Congress can't make one religion as the established religion of the country, and that's completely ahistorical. So you're absolutely right. As a legal perspective, the bedrock is the First Amendment. And it, for a long time, I would say actually underperformed, right? It didn't, from 1791 at the ratification of the Bill of Rights up until the mid 20th century, I would say that there were a lot of things that we would have had to say. Jefferson Madison would have hated this, but it was just kind of allowed because it was so common. And then it wasn't until the mid 20th century that we started to take a closer look at this and dive into the history and say, these common practices really are a problem. Things like public schools imposing mandatory prayer on students. So it's a relatively recent thing that we were able to kind of resurrect the original intent of these clauses and start applying them. And then, as you noted, that has eroded. That is starting to look like it might be, in the longer scheme of things, this kind of flash in the pan. And now we're going back to saying, well, let's just go back to allowing the government to endorse religion, which is, yeah, very, very concerning. So I wholeheartedly support your idea of let's make a clearer amendment to the Constitution that removes any doubt about what's going on. And my recommendation would be I would hit the major legal tests that have been used on this issue. So the first prong of the Lemon test is the purpose prong. So no law shall be enacted that has the purpose of advancing or inhibiting religion. I would say that. I would do the endorsement test, which is O'Connor's test. So I would say no law shall be passed that that conveys a government endorsement of religious belief. You probably have to be a little bit more specific because that's wishy-washy phrasing, but that's what the Supreme Court's gone with. There's also coercion, which I would specifically tie to taxpayer funding as well. So no one should be coerced to participate in or support religious activity. And I think that should explicitly include that no taxpayer can be forced to financially support any religious activity or organization. So we had a lawsuit about that in New Jersey. A lot of states have what are called no aid clauses that are similar to that. And I think that would be a fantastic thing to include. So that would be my recommendation. It'd probably be, I mean, I'm a lawyer, so of course it's going to be wordy, but if you asked me to write it, it would be a very clear and relatively long amendment laying out all the specific things that that the government where the government has transgressed state-church separation, say you can't do this, you can't do this, 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 and you could probably break it down into 5 or 6 categories, lay them all out very specifically, so that even quote-unquote originalist judges who are trying to get the results they want, which is pro-Christianity usually, are just saying, they're going to have to just say, my hands are tied. This specifically says we can't have a law that advances religion, and this does, or endorses religious belief, or coerces taxpayers to support religious organizations. So yeah, it's a big question. And I'll also say that right now we are working with some of those sister organizations, to tie it back to the previous question, to work on kind of a wish list of, if we had a very friendly Congress in 2021, what are some bills that we could advance that would make things better? Because the other thing is, the other kind of rain on your parade answer to your question is that, even though this is a wonderful pipe dream idea of how do we strengthen the First Amendment itself, the reality is that passing constitutional amendments when you have a divided country is astoundingly difficult. Passing laws is difficult enough in itself, but of course with the constitutional amendment, you need 2/3 of each house and then 3/4 of state legislatures ratifying them. That is just a big ask. So the question is, what can you accomplish through statutes as well? And the answer there is a lot, and so that's a whole topic in itself. But I think that's the other answer to your question, is all these things that you can try to fix that you would do if you could rewrite the First Amendment to strengthen it. How much of that can you kind of temporarily patch up through statute? So that's something else to think about. And if you have any personal ideas on that, about like, if you could just have Congress, snap their fingers and pass a law that fixes one specific issue, let me know, because I'm working with lawyers and all these groups to kind of just brainstorm at this stage what are some of those statutes and suggesting language for it. So I'm all ears for any thoughts people have on that.
Thank you.
I have to. Oh, go ahead, Bill.
The Minnesota Constitution, the state constitution, bars public money for religious purposes. And yet there's so many violations of that, such as religious exemption from local property tax and so on and so on. How is that? How can that be?
Yeah, wonderful question. And the answer is that these sorts of provisions are, so there's 2 steps to this, I guess. The first is that states, each state Supreme Court has to interpret their own state no aid provision like that. And different states have done that differently. So some have interpreted it very expansively, where the way that you would think, where you would say, not quite as expansively as saying there can't be any exemptions, I would say, but at least to say that any public program that gives money out can't give money to religious organizations, because the money is fungible and that goes to supporting their mission. So you can't force taxpayers to do that. Others have been more guarded and just said, well, we just can't use the funds toward religious purposes specifically. So if they're holding a revival event, we can't fund that. But if they just want to give out food at a food pantry, we can give them money, even though they're even though they're a religious organization. So I don't know the specific way that the Minnesota provision has been interpreted, but that's the first step to address that question. And I suspect, in terms of things like exemptions, I think that that's probably a roadblock for your where you're coming from. That probably the state Supreme Court has looked at it and said, well, there's a historical practice of exempting churches from certain things. So in other words, state-church separation has both benefits and burdens for churches. So they don't get to enjoy the benefits of public support the same way that secular nonprofits do. But because we want to keep state and church separate, we're also going to give them more room to do things that they're going to do. We don't want the state imposing its will on churches. So that's why churches have generally been viewed as being not entitled. I don't want to say entitled to exemptions, because I don't think that's right. But they're given more leeway with things like tax exemption than even secular nonprofits. When you look at the tax code, a lot of times it'll say all nonprofits get this, churches get this little additional benefit. And that is in the name of state-church separation. So love it or hate it, that's the way that most courts have viewed those provisions and state-church separation, is that churches do get more wiggle room than other nonprofits. So that's the first, I feel like that wasn't the clearest answer, but that's the first working piece that's going on, is that each state Supreme Court has to decide exactly what that provision means. And very rarely have they said it's absolute exactly what it says. They tend to strike a bit of a balance. And you're going to hear 11 gongs on there, I apologize. The other side of it that's even more concerning is that and the reason that we would be hesitant to pursuing those sorts of issues in court right now is that the US Supreme Court has been pulling really hard in the other direction, where when they were looking at, most recently the case was Espinoza, they look at these no aid provisions, and what groups like ADF, the anti-FFRF groups, what they want to do is they want the Supreme Court to say that all of those provisions of state constitutions violate the free exercise clause. So they want the US Supreme Court to just cross that out of the Minnesota Constitution and say, this is signaling out religious organizations for disfavored treatment on its face. That violates free exercise clause, therefore it's unconstitutional. And that's a crazy argument that would have just been laughed out of court 50 years ago. And nowadays we have to stop and think, oh my gosh, Brett Kavanaugh just might go for that. So we have to be very careful with how we move forward. And it's unfortunately, a lot of times it comes down to the specific facts of the cases. So if you think about a few years ago, there was a case called Trinity Lutheran, which was about a tire resurfacing program for elementary schools. And Missouri had a similar provision as Minnesota's. So the state said, well, these can go to any schools, but not religious schools, because the religious schools advance religion. We can't force taxpayers to fund that purpose. And so they denied the funds to a religious school. And they were able to really focus, groups like ADF were able to really focus that case on the facts of, they said, these are going to be kids skinning their knees. That's not religion. This is just a matter of keeping kids safe. Why should they be excluded just because these are Christian kids? And when you look at it that way, you can kind of understand why people like even Justice Kagan, people who normally are pretty friendly to state-church separation, kind of said, oh yeah, this does look like anti-religious discrimination. And so she and Breyer both went the wrong way. So that's the battleground going on there. It's a great question. We have this wonderful language in lots of states, and we are cautiously trying to enforce it, but you have to be really careful, because it's kind of one of these situations where if the dog chasing the car, and if you suddenly catch it, you don't know what you're going to do with it. Where if you suddenly get what you want, the Supreme Court might just come down and slap it down and say, this is going too far, this violates the free exercise clause, and that's the end of that party.
Thank you.
I have two questions. How I would have liked to have heard the argument. How could anybody growing up in our culture look at two religious crosses on public land and interpret that as not endorsing what the cross represents? What kind of acrobatics had to go on in order for that to happen?
Yeah,
That's I'll do both. Okay.
Yeah.
The second one is, I've run across this before, and this thing about sincerity, where if the court feels somebody sincere in what they believe, then the court says, well, then it's okay. We'll protect your belief, so you don't have to. So you're exempt from a law that the rest of us have to follow. That kind of thing. But what they're protecting is actually our imagination. And I don't know if any attorneys ever reframed it like that. Religions are just what we imagine. Nobody can show you anything. They can't show you their God. They can't show you anything concrete. So it's all in their imagination. All the stories, all the things, it's in their imagination. And how a court can, even if it's sincerely held, how a court can validate somebody's imagination more than somebody else's imagination is really bizarre.
Yeah.
If you use a little bit of cognitive science with it, it just is crazy. It really gets crazy. But
yeah,
anyway,
absolutely.
the first one and the second one. Okay.
Yeah, no problem. And I'll take them kind of in the reverse order because Scalia was actually, Antonin Scalia was the one who wrote this opinion that they're trying to overturn now called Smith in 1990, I think, where he made that sort of similar point where if you have, he wouldn't, of course, he never would have phrased it the way you just did, but he said, if you have everyone just saying, well, this is what I believe, and therefore laws don't apply to me that violate that belief that I'm asserting, well, then everyone is a law unto themselves. That's just it's an obviously unworkable system. And so it was Scalia of all people who held that up. And it was that decision that led to the Religious Freedom Restoration Act, because people were so appalled by it, they wanted to go back to getting special religious exemptions, which I think that kind of is a hint at the answer to your question for why people haven't phrased it that way. Because of course I agree with you. Like, you know, as I'm an atheist, of course I agree that someone coming in and saying, I believe this supernatural thing with absolutely no evidentiary support, and therefore I should get special treatment under the law. In my opinion, get out of here with that. That is just totally detached from reality, and you deserve no special treatment. But the common public opinion is that these are special beliefs, and we have to take people seriously. These are so important to people, so rich in our culture, yada yada. That if you were to write in a brief that what you were saying, that, you know, a quote unquote sincerely held religious belief is nothing more than someone's imagination, a court is going to just tear you apart with that, to say this is blatant hostility toward religious belief. You're giving no respect to the other side. And I think that unless you got a really friendly judge who just, you know, privately agreed with you, you're actually going to cost yourself a lot of credibility with the court, because they're going to say, I obviously can't put this in an opinion. So I am distrustful of the other things you're telling me now because you seem like an extremist, anti-religious person. So we have to be a little bit more diplomatic as attorneys, and kind of when we write briefs, we think about what could a judge realistically write? Because that's what we try to do. We try to make their jobs easy and write arguments out that they could just copy paste into their opinion and say, this is what's going on. And maybe we'll get there someday, but the idea of a judge coming out and telling people, well, your religious beliefs are nothing more than your imaginations going on in your head. I would love to see the day, but I think it will be a while.
There's some irony there that you have to protect the feelings of the judge who's caught by protecting the feelings
Yeah.
of somebody else.
Yeah,
well, we are an emotional animal, so I guess that makes sense. Okay.
Yeah, right. And judges always want to come across as impartial. So and there was even, you know, this instance in the Masterpiece Bake Shop case in Colorado where there was an offhand remark that was actually quite pro-religion, where it was, you know, about refusing to make cakes for gay weddings, where someone said, just in passing, after the judgment had already been made, a state official on a board said, by the way, I think it's awful that you would use religion to advance this kind of bigotry that hurts the image of religion and, you know, makes us all look like bigots, and I don't like that, basically. And the Supreme Court looked at that and said, well, this just shows that this person has this deep animus against religious belief, and so therefore the entire proceedings were invalidated as violating the Free Exercise Clause, which is just an astounding thing. But that's why we need to tread so carefully, and why judges do too. If they come across as being really hard on one side or the other, there's a risk that they look partial, and then they could get overturned. So that's the answer to that one, I think. As for the acrobatics with the crosses, the short version of it is that the trick with crosses, I suppose, the best way to look at it is that crosses have a dual meaning, where they obviously represent Christianity, but at the same time, they have this symbolism with graveyards and veterans, that when someone looks at a cross in this country, you might ask, what's the first thing you think of? And it's probably Christianity, but the second thing you think of is probably that maybe there's someone buried under that cross. And because of that symbolism, and there's so much of a history of artwork in the green fields of France from World War I with the poppies and the crosses and everything, that they basically said this is a dual purpose, and we shouldn't, they reframed, the acrobatics that they did is they reframed it as saying, if we look at something that has a dual purpose, and we say, well, one of those purposes is religion, therefore we have to get rid of the whole thing. Well, then what we're doing is we're not looking for an endorsement of religion. We're just digging in and rooting out any semblance of religion. And so that crosses the line into hostility. That's the way that they tried to reframe it. They also, of course, they try to get the facts to be as favorable as they can for themselves. So what you'll see in these cases is a whole record of facts that just create this muddy mess of things. And in the Supreme Court opinion version of it, they just pick out the facts that they like and lay them out, where when you read, if that's the only thing you read about it, it's hard not to agree with them, where they would say this was a cross erected after World War I, dedicated to the memorial. There were all these services about veterans. People hold events for veterans every year on it. And all the state wants to do is keep this monument to veterans from falling down. And when you put it that way, it's like, okay, well, I can then understand why you're saying this is not directly endorsing religion if that was all that they were thinking. It's just that that's a fantasy world. Of course, this is endorsing religion. And there's all these religious events that they held at the crosses that the Supreme Court just doesn't mention. So that's how they do that. They just reframe the facts and then do some legal acrobatics on the religiosity of it to say it's a dual meaning, and therefore it's a war memorial first and a religious memorial second. So therefore it gets to stay.
Okay, thank you.
Yeah. I see there's one other one here, so I can just read this out. It says, can't a super friendly Congress impeach any federal judge, including a Supreme Court justice, for, say, violation of their oath to uphold the Constitution? In theory, the answer is yes. They are very reticent about that. So the language in the Constitution is that federal judges shall hold their office on good behavior, I believe is the exact language. And what that has been interpreted to mean is, first of all, a lifetime appointment. That's not explicitly in the Constitution, but the question is, what does good behavior mean, or what would constitute bad behavior? And for sure, things like lying to Congress, or breaking laws. If you have a judge who robs a bank or something, that's clearly going to be impeachable. But in terms of judicial misconduct, where do you cross that line? And legislators are really nervous about the idea of diluting that principle to the point where they just say, and so this is me kind of speaking for them, because the long and short of it is I largely agree with you, but this is what they would say, is that when you start, if you were to start impeaching judges because you say, well, I think your oath of office means that you have to uphold what I think the Constitution means, and if you don't, we're going to impeach you for violating your oath. Well, that starts to look like anyone who's in power is just going to impeach all the judges that they don't like, and under the pretense that, oh, well, you're violating your oath because I think the Constitution means something different than you, and you're not upholding my version of the Constitution, so you're out. And we don't want every new Congress to just clean house in the judiciary. It's bad enough that that happens in executive agencies. We don't want a brand new judiciary every time a new Congress takes power. So that's why historically, when they've impeached judges, it's been a really, really high bar where you have to be committing some serious judicial misconduct before they would consider impeachment. So the theoretical answer is yes, but it would be almost impossible to get congressional support for that.
I have a question.
Yeah.
So I think it's just wonderful that you've been able to increase the size of the legal team. Is this because of increased support for FFRF? And if so, is this the growth of the nuns or those without religious affiliation? Is this having a positive impact on organizations like FFRF?
Yes, I think it absolutely is on both of those questions. So we have better support. We have more support now than we've ever had before. FFRF is cresting, I think, 33,000 dues paying members right now across the country, which is just fantastic. When I became an attorney here, I think we were at 25. So we are massively increasing there. And in terms of why that is, I think it's two things. One is what you mentioned, that yeah, the demographics are moving in our favor. So we have the expansion of the nuns. And then the other thing is we saw an absolute explosion in donations and support 4 years ago, and a lot of other other organizations did too. And again, I have to be careful because FFRF can't endorse candidates or parties, but I'll just say 4 years ago, there was a great deal of concern about a whole host of civil rights issues, including state church. So a lot of organizations saw this massive expansion in donations and support, and we benefited from that too. So that was that was definitely a major part in our ability to expand the legal team the way that we have been, without a doubt.
Ryan, I had a question about just very basic constitutional law. And so my understanding is that at the time the First Amendment was enacted, so what is that, 1791 or so?
Yes.
Adopted. So at that time, it only explicitly excluded the national government from involvement with establishment of religion and with religious freedom, and that the extension to restricting state governments came with the 14th Amendment, applying all the rights that you had as a citizen of the United States to being a citizen of Minnesota or something like that. Is that roughly?
Yeah, that's basically the idea. It's a funny thing. So the 14th Amendment, which was enacted right after the Civil War, protected all people against the, now I'm pretty good about the exact text, but yeah, in any event, it's what you said, where it protects people from equal protection of the laws, due process, and it prohibits any state from violating the rights of any person. So that was interpreted as saying just what you said, that if Minnesota is abridging your free speech, for instance, that violates not only the Minnesota Constitution, but if Minnesota didn't protect it, that violates the First Amendment of the US Constitution. So states and state subsidiary governments can't violate federal individual rights. Now, the interesting thing about it, though, is that because things can never be simple in legal world. What we went for as a country is, or as a Supreme Court really, is this idea of selective incorporation. So we decided to have a battle about every single individual right, about whether or not it would be incorporated to the states, because there are some that are considered either less fundamental, or they haven't been as helpful in practice, or it really is specific to the federal government in some way. So we decided we have to fight about every single individual one to decide whether this one has been incorporated. So there are things, for instance, like a grand jury subpoena that is a right you have under the federal government, where if you get charged with a federal crime, you have to get an indictment by a federal grand jury. That's in the Bill of Rights. But if Minnesota decided we're not going to do the grand jury system because the old aphorism is that a grand jury will indict a ham sandwich, so what's the point of wasting anyone's time with this? Let's just let DAs issue indictments. You could try to go and say, hey, this through the 14th Amendment and the 5th Amendment, I have a right to a grand jury indictment. I didn't get one. And the answer would be no, that provision of the Bill of Rights has not been incorporated to the states, which is just very strange. But that opens the door to what people like Clarence Thomas want, which is what they want to say is that we can start to peel back a lot of these rights. So he wants to say things like the Establishment Clause is not incorporated to the states. And so he wouldn't necessarily have to give up things like free speech and free assembly and search and seizure, these other basic Bill of Rights things, you could, in theory, parse these out and say, okay, you can still have everything else. So Minnesota can't just bust down your door and search without a warrant. But if Minnesota wants to make Buddhism the official religion of Minnesota, the federal government has nothing to say about that. That's Clarence Thomas's view in a nutshell. He's basically anti-incorporation throughout, but that's kind of a nightmare scenario of where the Supreme Court could go. But that would really be extreme. The incorporation doctrine, as you described it, is pretty well settled and agreed upon. And I think there would be academic uprisings if the Supreme Court started to undo incorporations.
So I suppose in the case of gun control, the same thing works the other way, so that a state can't have more restrictive gun laws than the Constitution seems to have, which is nothing, basically.
Yeah, that's right. And we call that a one-way ratchet, which I also thought was a funny term, because if it's what would a two-way ratchet even be? It would just be a wrench, I guess. But anyway, the idea is that the federal constitutional limits create a bar, or a floor, excuse me. And so state constitutions or state statutes can go above that, but they can't go below it. So for example, we talked about no aid provisions earlier, where we have the federal establishment clause. And even if the federal establishment clause says that it's okay to have a neutral program that funds that funds religious and non-religious programs equally, if a state wants to come out with a provision that says we give taxpayers the extra protection that no cent of yours will go to a religious purpose, you have the right to do that. That's the theory of the establishment clause. So there's a federal floor, state goes higher. The issue with the reason it gets complicated is that the establishment clause and the free exercise clause can be seen as being in opposition to each other. And so at some point, what they will say, this is what happened in Trinity Lutheran, is when this happens, when a state erects this higher establishment clause protection, is the Supreme Court could come in and say, well, now you've raised this protection so high that it's violating other people's free exercise rights. So we're going to strike it down for that reason. So that's kind of the game that they play, but that's the idea, is that the Bill of Rights creates this floor of protections. It applies to all the states. And if states want to create higher protections, they're welcome to do so.
People can submit questions via chat if you don't want to be on screen asking something. So there's if you cursor down to the bottom of the main viewing screen, you may only see more, which is what I see at the moment.
Check.
But if we click the three dots for more, or else you see a chat icon, you can direct a question directly to Ryan, or you can share it with everybody.
Hey,
I had a couple
Ryan, I have a
questions.
Oh, go ahead. I've already.
I was told that there's for example, getting back to the tax issue in church and stuff, stone business around Duluth here that is run by a church, and they're tax exempt, or you have churches with coffee houses and stuff. Is there situations where churches or religious institutions can operate some sort of a commercial enterprise without being taxed or having some tax exemption or whatever?
Yeah, there are some rules that they can play with, and I'm not a tax attorney, so my expertise with this is a little bit limited, but the basic answer is that within any 501c3's tax exemption, there is a certain amount of non-exempt activity you're allowed to do. Now, running a for-profit business is never going to meet one of those exemptions. You're not going to fit a coffee shop through that loophole. This is more things like if a church owns a whole structure that has all these different activities that go on, and one of them they rent out to someone, so they're collecting rental income. That's not a religious purpose. That would be a non-exempt source of income, but as long as it's a small portion of the money they come in, they would still not have to pay income tax on that. So that's one part of it. The other part of it is that there are sometimes you can have a religious organization that creates kind of sub-organizations under it that are under the overall umbrella of the religious organization and benefit from their tax exempt status. So we saw this in the LDS Church. There was about a year ago, I think, there was a big expose that came out that there was they were just hoarding all of this money and investing it in the stock market, just making lots of money, even though it had been earmarked for charitable contributions. They weren't giving it to charity. They were just investing it and keeping all the cash. And the way that they did it is that they had a subsidiary organization that was an investment firm, but under the umbrella of the LDS Church. So it had tax exempt status. And the practical answer to all of this that makes this so difficult is that secular nonprofits have to file paperwork with the IRS to prove that they're following all these rules. Churches do not. So when it comes to churches, if they say, we are this overarching structure and we have all these other organizations under us, and they're all under our umbrella of church nonprofit status, even though it's something like an investment company, they don't have to file anything with the IRS. So it is impossible to track whether or not they're actually obeying these rules. So you can't prove that they're violating them. It would be illegal for them to be bringing in too much non-exempt income, but they could easily be doing so. So until we make, the fix to that, I think, is to make churches follow the same rules as secular nonprofits, to say, if you want tax exempt status, you can have it, but you have to submit a Form 990 or other tax documents to the IRS to show what's coming in, what's going out, and to show that you're actually using it for charitable purposes. So that's kind of how they legally get around a lot of those sorts of things. But when you talk about brick and mortar businesses that are obviously for-profit entities like a coffee shop, they could be affiliated with a church, but I don't, to my mind, I don't think that there's a way that they could be running a for-profit restaurant or anything like that and not paying taxes on that. I don't think they would be able to get away with that.
But that subsidiary thing you're talking about makes me wonder about, you'd mentioned the seemingly endless stream of funding that some of these organizations are getting and hiring all these lawyers and was it the FDA or whatever? And it kind of makes me wonder about that.
Yeah, ADF. Yes,
ADF,
absolutely.
yeah.
Yep, it is a concern for sure. And the LDS Church is all these three-letter acronyms, but the Mormon Church is another organization that just has endless legal resources. So yeah, any loophole that they can stretch, they sure as hell will, as far as they can.
There's a specific, back on taxes, there's a specific exemption apparently for retired clergy where they get their entire household expenses exempted. At least that's what a retired clergyman told me. It includes all the house payments, painting, roofing, anything related to running a household. And I was told that they tried to get rid of this, but that all the congregations had their members write in because they would have to pay clergymen more if there weren't this exemption. There's some argument that they were provided housing by the church, so they weren't used to this expense, so they had to be made up for it. But it seems totally unfair and a violation of this law. Actually, I had a question about fraud. So if I tell you that for $100,000, I'll see to it that your body is reanimated and you'll get another 20 years of life, I assume I could be caught. If I can't offer any evidence in favor of this, I would be guilty of a fraud and bilking people. But if I tell you that I'll give you I'll resurrect you and give you eternal life, that seems like a bigger fraud rather than no fraud at all. So why don't fraud, so we have these statutes that protect people from being taken. Mm-hmm. What's the limit? Why don't they apply to claims that just can't be fulfilled?
Yeah, that's a really good question. I haven't thought about that before in terms of fraud. And I think your premise is correct that if you are offering resurrection services and you have no reason to think you can actually do that, that sure sounds like a fraud to me. But you offer someone everlasting life for eternity, and that's just religion. Yeah, and this kind of goes back to the earlier question about the, questioning the sincerity of people's beliefs and reframing it. Because I think the unfortunate kind of cynical answer to it is that because of the prevalence of religion, judges and lawmakers are just not willing to go there because they don't want to go down the road of saying, we believe that this person sincerely believes this, but this person doesn't, and therefore they're a fraud. Courts don't want to do that. And in a way, in the name of state-church separation, I kind of can support the idea that, I can see certain televangelists that I can see, like Paula White, for instance, to me, looks to me like I would just bet everything that she knows everything she's saying is BS. I do not think she's a true believer. There are other preachers who I would say, I think they really believe the things that they're saying. I think they're obviously very, very wrong, but I think they believe it. They're true believers. And so I am nervous about the idea of a court going in and saying which is which, because you wouldn't want someone who has true belief that they could do it, right? It's not fraud if you're not deceiving anyone. So if you are a true believer and you really believe in the afterlife and you can give it to someone, then you're not committing a fraud by charging a fee for that. You're just wrong. And that's different than someone who is doing what you described, where they know it's not true, they sell it anyway. That's a fraud. And so I think that's the real answer to it, is that lawmakers and judges are incredibly reticent to go in and start saying this person sincerely believes it or this person doesn't, unless you.
I didn't know that. So it's a condition on fraud that I not have a sincere belief that this thing is efficacious, so that anybody who's so rational people would be guilty of fraud, but irrational people who believe in this unsubstantiated remedy can never defraud anybody. But I don't understand that. It seems like it's a huge loophole in the protection against fraud.
Yeah, well, I mean, it's a matter of mens rea, right? So you have a fundamental criminal idea that you have to have criminal intent. Now, depending on what area it is you're talking about, there are other legal protections that would kick in. So there's things like strict liability. If you start hawking medical remedies that don't do anything, but you really believe they do, and they're actually really toxic, you're going to be guilty of a crime there, because there are protections against that. That if you make claims that you have medicine, then you are entering a product that triggers strict liability. And if someone gets sick, it's not going to be a defense to say, well, I didn't know. So there are areas of the law where there are protections for that. But when you're talking about just basic level fraud, and again, I'm not a criminal attorney, so I have no personal experience litigating any of this stuff. But my understanding of it, to the knowledge I do have, is that you have to be able to show that someone has fraudulent intent. If someone was just making a mistake, that's not fraud. And so yeah, that's it's a good thing though, right? Because you don't want to be out there saying what you really think is true, and you have reason to believe it, and then it turns out that you were wrong, and the evidence you had was baseless, and then not only is your reputation gone, but now they want to throw you in jail for fraud because you made a mistake. That seems pretty unjust.
Excellent presentation.
Thank you.
Yes, I agree.
Thanks so much, Ryan.
Yeah, absolutely.